afternoon, everyone, and welcome to our second panel. As promised, we're now going to deal in more detail with the Russian experience before the European Court of Human Rights and actually get into some nitty-gritty cases as well. At least I hope so. We have a very distinguished panel this afternoon, and I'll follow John's example and briefly introduce them, and then we'll move into the first speaker. Our first speaker will be Alexei Trochev, who is a lecturer at the University of Wisconsin Law School. He is a graduate. He received a bachelor's degree in Russian law from Syktyvkar State University. He went on to obtain a master's degree in public administration and a PhD from the University of Toronto. He has taught widely and has also published many important articles and monographs, most notably his book, Judging Russia, Constitutional Court in Russian Politics, 1990 to 2006, which I think has become the Bible for all of us who deal with the Russian Constitutional Court. Our second speaker this afternoon will be Tanya Lokshina. She is Deputy Director, Tanya, is Deputy Director of Human Rights Watch's Moscow office. Prior to joining Human Rights Watch, Tanya ran a prominent Moscow-based human rights think tank, the Center Demos, which implemented research and advocacy projects in such areas as human rights, violence in the activities of state agencies, effective implementation of international human rights standards, and so forth. She is also the author of several monographs, including her book. Her books include Chechnya Inside Out and Imposition of a Fake Political Settlement in the Northern Caucasus. And the third member of our panel this afternoon will be Anton Burkhoff. Anton is chair of the European and Comparative Law Department at the University of Humanities, and also the deputy director of the I've Got Rights program, which is sponsored by the Management Systems International Moscow. He previously worked for the law NGO Sutyazhnik, first as a lawyer and then as a project coordinator. He is an expert in a number of international and foreign organizations, in addition to his his law degree from the Ural State Law Academy. He earned a master's at the University of Essex in the United Kingdom, as well as a PhD from Cambridge University. So with that, we shall begin with Alexei. And Alexei, the floor is yours.
Okay. Thank you very much, Will. And so today I'll focus on Russia's experience with the European Court of Human Rights. And to appreciate it, we just need to think of Russian history. Right? Russian folklore doesn't have a single proverb portraying judges in a good light. Okay? History of Russia shows that there has not been any court that could order Russia's rulers to do certain things against their wishes. It's just historically, it's a very novel, unique, and surprising institution. And what's more surprising is the idea that common, ordinary Russian people can climb up, the stairway to heaven, and even though there is a cloud and they don't see, they don't know what awaits them on top of those clouds, but they're still trying to reach it. And on that other level, from the Strasbourg heaven, there is an independent judge or independent court that tells Russian government to do certain things. Okay, that's historically it's unprecedented. So if we look at the statistics, the public opinion about Russian court, we see that huge jump. Right, it's the most popular court in Russia. So the statistics is clear. I don't want to repeat it. I just want to mention that at the same period, trust or popularity of Russian domestic courts declined dramatically. So in '96, about 40% of Russians were ready to sue in court against Russian government officials or Russian government if it violated their rights. In 1996, 40%. In 2004, only 1% of Russians said that they would challenge government action in domestic court. So the trajectory goes the opposite way in terms of perception of Strasbourg court in Russia. And the idea is here that this perception, of course, is wrong. As we know it, the court refuses or rejects complaints from Russians, just like from any other citizens of other European countries, 95% of the time. It's very difficult and very long process and so forth, but public perception, nevertheless, is very favorable to European court. Okay, no other Russian court has these approval ratings. Okay. Now, why do Russians overload the court? Already today we talked about that. Just to handle Russia's cases, they need a separate European court. Okay, that's the share. So why do they overload? Is for two reasons. The cost is very low. Cost of complaining to Strasbourg is very low. You need to lose basically 2 court decisions. Okay, or in cases coming from Chechnya where there was no courts, you could just show evidence that you try to complain to the law enforcement agencies in Chechnya, so you don't have to do these 2 court decisions. And in cases where you complain about non-enforcement of these court decisions that Russian courts issued in your favor, there you don't even need to lose 2 court decisions, because you are complaining against a non-implementation of a judgment. Okay, so the another requirement is that you have to file a complaint within 6 months from the moment you learned about the violation of your right. Okay, and then the third condition is that you have to rely on the rights mentioned in the 1950 European Convention. Okay, Russian Constitution was written in 1993. Many of rights mentioned in the Russian Constitution were copy-pasted from the European Convention, so it's a familiar language to many of the complainants. Okay, so the process looks very easy, at least initially. Okay, of course, doesn't accept everything and has developed its own ways of screening out complaints and returning complaints back to people. They have to rewrite, they have to fill out more, provide more evidence. But that type of ping pong, of paperwork is familiar to Russians. They dealt with Russian bureaucracy. They are well trained in filling out all sorts of paperwork and certificates and asking for receipts and so forth. Complaining is also cheap to Strasbourg court. All you need is a stamp, international stamp, to send it to France, right? You don't need a lawyer initially to file it, and it's similar to Soviet-style writing letters to the editors of newspapers. Okay, basically you tell your story. So again, for Soviet mentality, it's very familiar. You write and complain, even though you have no idea what happens next after the court receives the complaint, but you just write it. You don't need to go to the courthouse, Russian style, where there are no bathrooms, where there's a line. You have to wait in the corridors of the courthouse, where in the crowded. So you sit at home and you wait, right? That's a typical, just like you wait for good weather. Yeah? You wait for the response from Strasbourg. When Strasbourg replies, they call you dear sir or dear madame, right? And some of the complainants were very happy. They are addressed for the first time, old retirees. They are very happy that they are treated with respect and so forth. So that's, again, perception, and the cost of complaining is cheap. If you look at the statistics, again, 1999, first year when Russians received the right to fill out, actually send complaints. So we see a dramatic jump, right? In 10 years, the real number you should focus is this. Okay, that's the cases that actually Russia has to do something about. Okay, so in this jump we see that it's an overload. It's an overload. Okay, and statistics, we already talked about this in the first panel, that statistics, it's so popularity breeds action on the part of citizens. Okay, that's the basic idea. So again, statistics, Russia is red, almost 29% of all complaints and it really the court really needs a separate court just for Russia. Okay. Now, what kind of complaints Russians bring to a European court? Traditionally, up until the last year, about 40% of them complaints were about non-implementation of decisions of national courts, which means that Russians win their cases against pensions, childcare subsidies, property transfer, against the wrongful decisions of government officials. So they win in domestic courts, okay? But the government, regional governments or federal governments, they refuse to pay out court-ordered compensation that the domestic courts ordered, that the plaintiffs won, okay? And 15% is excessively long trials in criminal cases and in civil cases. Last year, statistics has been changing. So Russia lost 217 judgments. Again, just the total number of judgments you should not think that it's some kind of exceptionally large number. Turkey, Ukraine, they are on the same category in terms of losing judgments. And one thing that we should remember is that once the Strasbourg court accepts the complaint or accepts an application, accepts a case, there's a 95% probability that the government will lose, okay, across the board. So that's just to keep that in mind. It's not just Russian cases that are lost all the time. So if you look at this, again, statistics is very bad. Inhumane treatment, right to liberty, right to life. These are cases about human lives, about survival. So basic necessity. So this trend is more alarming than those non-execution of decisions of national courts. Okay. Okay. Who wins the cases? What media portrays? What Russian media portrays about winners? And we see that all sorts of people win cases. Generational, gender, rural, urban, professional, different people win their cases. And the media reports about them. We know that Russian population is, readership is not usual pastime anymore, but still these stories get attention of ordinary Russians. And again, it breeds the popularity that it's possible to file a complaint to Strasbourg and wait, and eventually you get a victory. Okay, that's the perception that the media creates. No matter what the Kremlin is telling Russians, that Strasbourg is biased or politicized or slow, inefficient, Russians believe this more than the Kremlin. Okay. So, what do losses mean for the Kremlin? Is that it's a growing headache. Initially, it was a scandal. Every loss was a scandal, but by now, out of 1,000 judgments, 95% are lost. Ukraine loses the same thing. Turkey loses the same thing. So pain level, tolerance of pain coming from Strasbourg has decreased. Okay, so they tolerate. Well, if everybody losing at that, we lose too, and not a big deal. Especially that we can get away with just paying out the court-ordered compensation. Okay, so almost every decision of the European Court of Human Rights won by ordinary citizens says that you have to pay out, Russian government has to pay out certain compensation. And sometimes even when plaintiffs do not ask for compensation, court awards compensation no matter what. There was a case about hazing in the Russian military, which is a widespread practice. The plaintiff complained that he was forced to do 150 sit-ups, but he had a bad health and he ended up in the hospital, and he didn't ask for any compensation, but judges said, well, 10,000 euros for this ill treatment. Okay. So, what to do with this? And what to do with this powerful court, surprisingly and shockingly popular court? the Kremlin chose the short-term practice, short-term attitude, the short-term approach to stem the flood of cases coming to the Strasbourg court. Okay, so that the fewer cases get there, fewer losses for Russia, or we can slow down the work of the court, just like delaying ratification of the 14th protocol that Will talked about. So the court is slow, the number of losses also low. Okay, that's the idea. But again, the media shows that it's possible to, the citizen against the state in the European Court of Human Rights is really a winner. The Russia's representative, is ashamed of himself that he lost the case again and again and again, and so that's the headache. Okay. So how did they deal with? How does Russia respond to European Court of Human Rights to this headache? So in addition to stemming the flood of cases, most often it involves cooperation with the court. So whenever court asks for documents, additional evidence, when they ask the Russian government to reply, to settle, the Russian government does something, okay, positive, except in the cases involving Chechnya. They do not share case files. So, and therefore, they refuse to cooperate in the cases coming from Chechnya and North Caucasus, they attack lawyers, and they make all sorts of bad things for people or their representatives who file complaints from Chechnya. Okay. Almost always Russia pays out compensation ordered by the court. That we already mentioned this. There's only, I think, one case that involves Russia and Moldova as defendant, and that in that case, Russia still, I think, refuses to pay out that compensation. So this is why Russians think that this is also most powerful court. So it's most popular court, but it's also most powerful because it makes its decisions stick. Okay, its decisions have teeth that Russian government obeys almost always, and for Russians who complain, single mothers about childcare subsidy of $17 a month, right, or a pension subsidy, of $50 a month. These are big things that when the court rules in their favor, and the government complies with that. Okay, and the way they comply is they ask the winning litigant to provide bank information, and then within, I think, 3 months they pay out. And if they don't pay out, the litigant goes back to the court and complains, and there is more paperwork on that subject. Okay. Okay. So popularity and the power. That's the two things about the court. Okay. So in the image of Russia, then it's, the justice, Lady Justice has her hand, jury's touch over the whole Europe, and this magic touch is really powerful and popular. Okay, and it's really independent, right? Impartial and so forth. And if we compare it with the Russian view of Russian judges, you can see that bureaucrats are playing games, making fun, depriving of the scales, of the sword, and it's not to be taken seriously. So that's one of the ideas in the Russian mind about differences between Strasbourg, which is unknown, and Russian courts, which are more known, but they are known in negative way, unpopular way. Okay, now if you look at what Russia did with responses other than paying out compensation, Russia changed many of its laws. Right? Putin has majority in the parliament, no problem, not like Yeltsin, right? So he could make all sorts of changes in legislation to bring the Russian law, at least with standards of the European human rights standard. Okay, so they tackled that issue of non-implementation of judicial decisions, and they said the European Court issued a pilot judgment that Will talked about. The Chernobyl cases, Chernobyl cleanup workers keep complaining to the court that they don't get their disability pensions, and the court eventually said that Russia, we won't hear any more of these complaints, but you have to adopt a domestic remedy for this. So after 1 year, actually almost 2 years of drafting, they come up with the law, with domestic remedy, and they very narrowly applied. They said that we will give out compensation for non-implementation of against lengthy trials and against non-enforced judicial decisions in cases involving federal government as a defendant, only in cases involving federal government as a defendant. Okay, so this is not about compensation for, let's say, if bailiffs do not enforce your decision, the bailiffs are not in this picture. Okay, they borrowed this law model from Italy. Okay, because Italy had the same problem facing. I mean, Russia borrowed a lot from Italy. You know, plea bargaining in criminal justice. I'm not going to talk about this, but they borrowed that law too, and it became very popular. And so, if you look at the how Russian courts were dealing with this, how they use this domestic remedy, it's not used very much. Okay, so we completed in 6 months of this new law. Since this new law was enforced, we have 28 cases completed, which means they entered in force, and there is no possibility of appealing. Right, so 28 cases, $70,000 total compensation. So it's not very popular, I would say. And then there were 233 cases were pending. So we'll see how it will go, and how Russian lawyers will treat this domestic remedy better than the Strasbourg real remedy. Okay. So if you don't like this remedy, you get too little compensation, you can go to Strasbourg and complain that the amount of award is less than Strasbourg award, real award, so you can get that. You can get that thing. And another thing about the Russian judicial system, somebody asked a question about business litigation. Another side of the popularity, why European Court is popular, comes out in the practice of arbitrage courts, or commercial courts that deal with business disputes and disputes between businesses and governments. So in the area of taxpayer litigation, when taxpayers, business people, corporations complain against too much tax penalty levied on them, Russian commercial courts took European Court as a shield or as a weapon to punish the tax authorities. Okay, and they say that, well, according to European Court of Human Rights, it's okay to lower the tax penalty or to just delete it or to cancel it or at all. So now lawyers who represent businesses in the taxpayers cases or just small businesses themselves, they learn about this, and they always ask for leniency and for the reduction of the tax penalty or abolition of the tax penalty, and they say, well, that's because European Court of Human Rights told us that we have this right. Okay, that's another aspect of the popularity of European Court. So to conclude with the bigger picture, international human rights, European human rights system may work in Russia. How well it works, we'll hear more today. But it needs 3 elements. First, it needs an enforcement mechanism, and with Russia, I think it's not illegal, it's not the law that enforces it, but it's this international public shaming of Russia, because European Court is telling the whole world is that even though Russia cannot breaks its promises to pay, minor childcare subsidies or pensions or certain payments, even though, Vladimir Putin said that Russia is a superpower, he brought law, order, and prosperity to Russia, but paying out $3 childcare subsidies to a single mother is somehow not in the picture. Okay, so this image of image of European Court of Human Rights really goes against this promise of Putin of stability and prosperity. Okay, then another thing is the supportive institutions. You know, it's nice to have bills of rights, open government agencies, you know, friendly to citizens. Okay, and again, these institutions have to have an interest in maintaining this human rights system. Okay, and so far we see that some parts of the judiciary are more friendly to European Court of Human Rights, others are not. Police, prisons, defense ministry, right? These are all big, let's say, resistant institutions that really resist. And then the third thing, we need to have allies on the ground. Okay, and I think the big thing here is, since Russian people already know the court and ready to activate it, we just need to have lawyers to insist and to write their complaints in the way that European Court of Human Rights would understand them and accept them. Okay, and then we need judges, of course, that, and Anton will talk about them. And then we need also bureaucrats. Okay, those who actually deal with the public, with citizens, and who treat them nicely or treat them wrongly. Okay, and then if we have these three at least, then maybe the rights will help reconfigure state-society relations and take Russia, you know, from its history of arbitrariness and distrust in judiciary to some kind of rights-respecting culture. Thanks.
Thanks very much, Alexei. And we'll now turn to Tanya.
Thank you very much, Will, for giving me the floor. I was asked today to speak specifically about implementation of ECHR judgments, and especially the judgments that pertain to Chechnya. Now, I would like to start by saying that the general situation with implementation of Strasbourg rulings in Russia is really not hopeless at all. And this is something that you already heard from the first distinguished speaker, and this is possibly something that Anton is also going to talk about.
There'll be no more PowerPoint.
Chechnya, at the same time, as usual, is a very special case, because in over 170 rulings, the European Court on Human Rights has held Russia responsible for serious violations of the convention in Chechnya, and particularly torture, extrajudicial executions, and enforced disappearances. This is really a crucial mass of cases. However, those rulings are not being implemented on substantial level at all. If you look at Russia's implementation record in general, there is some progress with execution of judgments by domestic courts, which was just noted. There is some progress in the penitentiary system, which was actually kick-started by the first case Russia lost at the European Court, the case of Kalashnikov against Russia, a prisoner in pretrial detention who was living in such poor conditions, actually typical for pretrial detention in Russia at that time, that the court qualified those conditions as equal to inhuman and degrading treatment. And Karina Moskalenko, who's sitting there in the back of the room, she actually won that particular case. I don't know whether she's going to mention it in her presentation, but she is indeed behind a major penitentiary reform in the Russian Federation. But with Chechnya, there is just no progress. In practically every ruling, the court called the Russian government to account for failing to conduct an effective domestic investigation into the crimes committed. In about 50 cases, Strasbourg also stressed Russia's refusal to share with the courts documents about, from the criminal case files, which were necessary to the court. And therefore, Russia essentially undermined the work of the court by violating its obligation to quote-unquote, furnish all the facilities to support a thorough examination of a case. It has been just over 6 years since the court issued its first ruling on Chechnya, and implementation-wise, the Russian Federation has been continuously doing the easy part, that is, paying the monetary compensations to the victims and according with the court's rulings. However, it has not meaningfully implemented the core of the rulings. It has not taken either individual or general measures prescribed by the court. In other words, Russia failed to take sufficient steps to ensure effective investigations into relevant cases, hold perpetrators accountable, or prevent similar violations from reoccurring. To emphasize, timely payment of the compensations required by the court cannot be underestimated, and it does show a certain degree of cooperation by the Russian Federation with this key European mechanism for human rights protection. At the same time, the court is not about money. The court is rather about the member states of the Council of Europe being in compliance with the European Convention. So unless systemic substantial measures are taken by the states, the rulings remain relatively meaningless. And that's what's happening to the Chechnya rulings today. In Chechnya and other republics of the Northern Caucasus, abductions and forced disappearances, extrajudicial executions, and acts of torture continue on a systemic level, and new cases as a result are being brought before the court. And those new cases are essentially mirror images of the cases already ruled on. So Russia is apparently not doing its job, and the situation is quite unacceptable. Full implementation of the rulings means real and long-awaited justice for Chechnya and the innumerable victims of this protracted and bloody armed conflict. When all the struggle for accountability for these crimes in Russia results in a failure, having knocked on all doors on domestic level, all the venues provided by the domestic system, they actually turn to the European court as their last resource and hope. And as has been emphasized before, the European court indeed is a court of last resort for Russian citizens in general. But for Chechen residents and residents of other turbulent republics of the Northern Caucasus that suffered from abductions, disappearances, that lost their family members in extrajudicial killings, the European court, I would argue, is the court of one and only resort, because they proved to be absolutely unable to find any justice on domestic level. In July-August 2009, Human Rights Watch undertook research to examine Russia's implementation of the European Court judgments on Chechnya through interviews with applicants and examination of legal documents. So in September last year, we released a report based on the research findings. This report is titled, "Who Will Tell Me What Happened to My Son?", which is naturally a direct quote from an interview with a Chechen mother who lost her son to an enforced disappearance. I went on a special mission to Chechnya, interviewing 33 families who won their cases in the European Court. Some copies of the report were made available for this conference. They're outside the room, and I really encourage you to take a look. So when I was interviewing those people in Chechnya, and personally I've been working in Chechnya for about 9 years, I was totally struck by their naked disbelief and hopelessness. They are supposedly the winners, right? But nevertheless, they waited for those rulings for years with bated breath, and they were elated when the judgments finally came. Yet what they were waiting for was not the money. Some of them actually did not even know that a financial compensation would be involved. They were rather waiting for information and justice. And then, in the aftermath, they can hardly resign themselves to the fact that all they get is a compensation. And certainly they got their compensations without delay, and 20 to 40,000 euro in average, sometimes even more. That seems like a lot of money for a place like Chechnya. While the luckier family that I interviewed spent the awarded compensation on rebuilding their houses destroyed by the war. The truly unlucky ones, whose relatives were disappeared, mainly spent the money on repaying the debts, because throughout the years of looking for their loved ones, they were paying bribes to each and every law enforcement and security officials who pretended that he could provide some information, and the accumulated debts would essentially amount to the compensation received. And in any case, what exactly is it to a mother to receive 40,000 euro for the loss of her son? Does it qualify for justice? No, it does not. And from 1999 to the present, up to 5,000 people were disappeared in Chechnya, and impunity for these crimes has been absolute, with only one single security official ever held accountable and put to jail. And before people in Chechnya see justice for those crimes, a meaningful resolution of the conflict just does not seem feasible. Full implementation of the court's judgments means not only that Russia must bring perpetrators to justice, and sometimes the perpetrators are known, as in very well known and identified in relevant judgments, including 3 Russian generals that were responsible for particularly abusive operations, while one of them actually gave direct orders to shoot a prisoner. And that was filmed by a CNN stringer, and it was literally all over the news, on television, internationally. So implementation of those more systemic changes, of those policy changes in line with the court judgments and aimed at stomping out relevant violations in the future, the changes that are in other words called general measures, their implementation is supervised by the Committee of Ministers of the Council of Europe. And the Committee of Ministers identified 4 areas of focus in the Chechen cases, namely, improving the legal and regulatory framework governing the work of the security forces. Secondly, raising awareness and providing training to members of the security and law enforcement agencies. Thirdly, improving domestic remedies in cases of abuse. And lastly, improving Russia's cooperation with the European Court by providing case files and all the necessary documents. Russia formally cooperates with Strasbourg. It submits periodic reports regarding implementation of the European Court judgments, the reports that the Secretariat of the Committee of Ministers looks into on a regular basis. In the reports, Russia details the steps it has taken to comply with general measures. The Secretariat of the Committee of Ministers approved of some of those changes, but still noted its dissatisfaction over the inadequacy and incompleteness of others. In particular, it expressed concern that Russian authorities' efforts to implement the court's rulings are not sufficiently systemic and coordinated. It invited the government to provide more information about the steps undertaken in this regard. Also, some of the steps of which Russia appears to be particularly proud, they may look impressive on paper, but in reality they're rather meaningless. For example, as part of the measures taken to implement Strasbourg judgments on Chechnya, Russia opened a special division within the prosecutor's office for the Chechen Republic, where investigators work specifically on Strasbourg cases and are supposedly given a special mandate. However, the work of those investigators has not changed at all and demonstrates no effectiveness whatsoever. So the new unit is there, and it looks good on paper, and it looks like a very concrete and substantial measure, but there is no difference in practice. And I remember quite clearly how a good colleague of mine, who was working on a very sensitive recent disappearance case in Chechnya, spoke to a chief investigator from that special unit with supposedly broad powers, demanding that the chief investigator interrogate a suspect who happened to be a police officer under Mr. Kadyrov's control, under control of the Chechnya president, working in one of those high-profile law enforcement units. And the chief investigator from that department said loud and clear, "Do you seriously expect me to interrogate that guy? There is absolutely no way, because if I send him summons, he's not going to show up. And then his mates are going to wait for me by the prosecutor's office buildings, and they'll slap me in the face." So that kind of shows you the degree of effectiveness in practice. In April 2009, the Parliamentary Assembly of the Council of Europe expressed concern about Russia's selective and inadequate enforcement of European court judgments and concluded that the human rights situation in Chechnya is, quote-unquote, by far the most alarming in the whole of the geographical area covered by the Council of Europe. Likewise, the European Committee for the Prevention of Torture has on 3 separate occasions issued public statements to draw attention to the lack of cooperation from the Russian authorities. Yet, despite these public admonishments, Russia has failed to take serious steps to carry out the general measures required by the European Court. Needless to say, the task ahead is absolutely enormous, and there are multiple very significant challenges. As the number of judgments on Chechnya has grown, the European Court has used increasingly strong language in its rulings against Russia. For example, in its 2007 ruling on the case of Musayev and others against Russia, which involved the massacre of civilians by the Russian forces, the court stressed that 6 years after the cold-blooded execution of more than 50 civilians, there is no meaningful result whatsoever as far as the investigation is concerned. Actually, the court, as we have already heard here, describes the ineffectiveness of Russian investigation authorities as quote-unquote astonishing. Another serious challenge is the growing hostility on the part of Russian officials and their manipulation of the country's geopolitical importance to Europe in order to discourage European leaders from actively engaging on human rights, including an implementation of Chechnya judgments. Russia also systematically criticizes the court in connection with its judgments on Chechen cases, well, some other judgments as well, and calls those judgments particularly politicized. Despite those difficult challenges, however, some windows of opportunity are certainly in place. Russia does show signs of willingness to cooperate with the court. Monetary compensations to victims are paid out without failure, and periodic reports are submitted to the Committee of Ministers without delay. This is something which I've already stressed. Also, general measures have been implemented for some of the European Court judgments outside of the Chechnya context, something that we've already spoken about as well. Moreover, as ambivalent as it may sound, I believe that the very fact of Russia lodging 3,000 applications on alleged violations by Georgia in South Ossetia on behalf of South Ossetian residents shows that Russia does perceive the court as an important mechanism to ensure accountability. While those were essentially complaints put together speedily by staff members of Russia's prosecutor's office, the quality of those complaints was really very poor, and they ended up being rejected by the court. But it's just important that Russia made this particular effort. It simply means that it deems the court to be a very significant player. Finally, to the overwhelming excitement of its European partners, last year Russia has long awaitedly ratified Protocol 14 to the European Convention, that key mechanism that would help the court expedite the processing of cases and overcome the problem of the ever-growing backlog. President Medvedev's own pride in his legal education and his rule of law rhetoric are also a window of opportunity in their own right. In other words, there is no better time than right now for Russia's international partners to raise the issue of effective implementation of the European Court judgments with their Russian counterparts. The Committee of Ministers and other Council of Europe institutions have an important role to play in monitoring and ensuring Russia's compliance with the court's rulings, but their efforts need to be reinforced by member states of the European Union, which should all make the full implementation of the court's rulings a key element on their agenda with Russia. So essentially what we are trying to get the EU to do is to become very proactive on the issue, to actually take this issue outside of the confining boundaries of Strasbourg and move it to the level of Brussels, so that European capitals would engage directly with their Russian counterparts. One of the key recommendations in our report was, in fact, in calling the European Union to establish, in coordination with the Council of Europe, a permanent European Union working group consisting of Moscow-based diplomats from the EU member states, the European Commission, and the European Council, with the objective to engage directly with Russian authorities and offer technical assistance where appropriate, and to ensure Russia's effective implementation of the European Court's judgments. In our view, this working group should use as a basis for its activities the assessments prepared by the Council of Europe bodies in this area, as well as input from individual lawyers and NGOs representing victims in the cases. And needless to say, the NGOs and the lawyers are more than willing to cooperate. The United States, though not bound by the European Convention on Human Rights, can also play a significant role in this debate by raising the issue of effective implementation when discussing rule of law challenges with their Russian partners. Finally, I would like to say something that pertains directly not to the issue of implementation, but to the sorts of complaints that the European Court receives from Chechnya today. All those judgments, over 170 judgments that I was referring to, are essentially judgments about abuses perpetrated by federal servicemen in the early years of the Second Chechen War. As far as the contemporary crimes are concerned, as far as abductions, disappearances, and acts of tortures and extrajudicial executions perpetrated by the so-called Kadyrovtsi, law enforcement and security officials under Ramzan Kadyrov's de facto control, very few complaints of that nature actually reach Strasbourg. And the reason is very simple. Chechnya today is paralyzed by this overwhelming climate of fear. And as someone who worked in Chechnya for many years, I can tell you that early in the war, when everything looked so much more frightening on the outside and Grozny was completely leveled with ground and there were bombings and shellings and whatnot, you'd come to any village and people would run to you. They would want to talk to you, even if they had the understanding that you could not help them in their individual cases. You really could not render any immediate assistance. They would still want to talk to you just because they wanted the world to hear their stories. They wanted the world to know what was happening to them. Nowadays, it's quite to the opposite. You can actually find out that someone was abducted from this particular village. You come to the village, you knock on the door, and the family tells you to go away because they're frightened of repercussions. A couple of years ago, I was researching collective punishment practices in Chechnya. For example, punitive house burnings, when houses belonging to family members of insurgents are torched by law enforcement and security officials by way of punishment, to punish the families and to thereby force relevant insurgents to surrender. Well, I interviewed about 30 families who lost their houses in that manner. Only 5 of them actually dare file official complaints at all. Then, without exception, they all took back their complaints, because the next day, law enforcement officials showed up on their doorstep saying, "Did you actually send a complaint to the prosecutor's office? You have to go there right now and write a letter saying that your house burned because it's your own fault, because a candle overturned during the night, because a little piece of burning coal fell out of the stove." Whatever you tell them is up to you. But if you do not withdraw that complaint, you will know what trouble really means, because losing your home is just not bad enough. And this is the situation in which we are in Chechnya today. The only people who complain to the European Court now, in my experience, are victims of enforced disappearances. That is, families of the disappeared. Because if a person is killed, no matter the injustice, at least they get a body to bury and they lay it to rest. The fear is too overwhelming for people to try to even fight for justice. With the disappeared, they're so desperate for any information that they overcome their fear and try to do something. And there are about 6 cases of enforced disappearances from Chechnya that were lodged with the European Court during the past year. Thank you.
Good afternoon.
No.
That's okay. I don't. I thought I would use presentation, but listening previous talks, I thought I would need to add something and improvise. I'm going to speak about motivation for direct application of the European Convention in Russian courts. And when I'm thinking about motivation in this regard, I'm comparing it with motivation to study a particular law subject and then taking an exam, and then thinking whether many students will actually study hard a particular subject if there is no exam ahead of them. So that relates to the application of the European Convention in Russian courts. Right now, I think there is no course on direct application of the convention and neither exam which will motivate judges and lawyers to domestically apply the convention, and I will explain this in my talk. So 1996, Russia joined the Council of Europe. Before that, there was a research done by the Council of Europe whether Russia is ready for the Council of Europe, whether Russian legal system complies with the European standards. There was a group of lawyers which went to Russia, did a research, and the conclusion was that it was prior to accession to the Council of Europe. The conclusion was that the Russian legal system is not in compliance with the European standards. Interestingly enough, Ministry of Foreign Affairs of the Russian Federation made the same research and arrived to the same conclusion. Russian legal system is not, with the exception of the constitution, is not in compliance with the European standards. But the accession actually took place. There was a compromise saying that it's better to accept Russia and help further to bring Russian legal system into compliance with the European standards than to leave Russia apart. So 1998, Russia ratified European Convention as one of the conditions of joining the Council of Europe. And the idea of the European Convention is not that since this very moment after the ratification, everybody in the country, in the state, can bring a case before the European Court. It's actually the opposite. It means that every citizen under the Russian jurisdiction, in the case of Russia, receive a right to use the European standards within the Russian legal system before going to the European Court. It's like taking human rights, international human rights, to Russia, to the national legal system. And that was absolutely needed because of this research, the situation before the joining the Council of Europe, that the Russian legal system doesn't comply with the European standards. So you actually have to take the international European standards and use them in the Russian legal system. So let's see how it worked, and I'm going to be speaking and using an experience that Russian NGOs had in Russia, and particularly the NGO I was working for many years. So in 1998, that was actually when Russia ratified the convention. My colleagues at the NGO started to think, what can we do about this European Convention? So what is this? And none of the lawyers in our NGO has any course taken on the European Convention, so we basically didn't know what to do with this. And not only lawyers of NGOs, nobody knew what to do with this instrument. And I will give you an interesting example pictured by the current judge of the European Court, elected from Russia, Anatoly Kovler. He published an article where he said in 98-99 there was a public discussion between the head of the Constitutional Court, it was Baglai back then, and the head of the Supreme Court, Lebedev. He's still the head of this court. they were arguing which was the last instance, judicial instance, before going to the European Court. And the point of view of each of these highest court judges was that the Constitutional Court is the last resort. The Lebedev point of view was that the Supreme Court was the last resort, and only then you can go to the European Court. But the point is, none of those courts are the last resort. You can go to the European Court after you have a decision heard by the cassation, which not very often is the Supreme Court, and of course not the Constitutional Court. The result of this public debate was in the Rossiyskaya Gazeta, Russian newspaper, an official source, and it brought a lot of confusion to citizens. And so that's why we have right now, and has been having, a lot of inadmissible cases pending before the sent to the European Court, on the ground that citizens miss 6-month time period allowed to bring a case before the European Court, because people would go to the Supreme Court to exhaust this nadzor remedy and miss the term. So this is the picture that nobody actually knew what to do with the European Convention, and that the European Convention is not actually what is written in the text, it's what is in the judgments on the case law of the European Court, which is also was foreign for Russian legal mentality, because the Russian lawyers are accustomed to look at the text of the law, not at the practice of the courts. So we faced this situation in our NGO and started to think, okay, where can we get this knowledge on the European Convention? No courses in law schools, no local experts. So we established a joint venture with foreign NGO, Interrights, based in London, and with Essex University, which is famous for the experts and professors on the European Convention. And it was a 1.5-year long training course. Every second month, experts from Essex University and Interrights would come to the Urals, Ekaterinburg, and we teach a course, 2 to 3 days course on the European Convention, particular articles. And finally, with a 7-day-long exhaustive training on the European Convention moot court. So if we got the basic understanding of the European Convention, started to use this instrument not by sending cases before the European Court, but actually in our domestic litigation, we try to see whether in this or this particular case we can use arguments based on the European Convention and the case law of the European Court. And we realized that the convention is not actually a remedy which you can use everywhere. It's actually can be very, very much limited. And we faced, so when we start to argue cases before national courts, we're faced with resistance from the judges. The initial reaction was very strong, and sometimes we would hear, sort of quoting, if once again you party, an applicant, would argue the convention, or you mentioned the convention name, I would call the bailiff and you would leave the courtroom. Sometimes the judge would say, why do you mention foreign law? So there was no even understanding that under the Russian constitution, ratified convention on the European human rights is a part of the Russian legal system. It's not a foreign law, it's Russian, it's national. Or sometimes you would hear, we are not a common law country, it's a civil law country, we don't use precedents. Why do you argue this judgments of the European Court? And then they would say, give me official translation, go to the notary public and notarized the translation. With the conversation with one of the judges, chief justices of the district court, the judge says, well, how can you apply a judgment of the European court? And was actually advanced, anyway. How can I apply judgment of the European court published in a journal? There is a journal, Bulletin of the European Court of Human Rights, but it's published by the NGO, Russian Lawyers Club, I think. He said that that's not an official publication. If this publication would be in the Rossiyskaya Gazeta or the Bulletin of the Supreme Court, that's a different matter. But it was 99, 2000. The situation changed quite a lot, and not only at the level of the Constitutional Court or the Supreme Court, but at the level of district courts. And actually, the situation in district courts can be much better. Constitutional Court is quite often issue decisions, judgments based on the European Convention, and analyze cases of the European Court, not only against Russia, but against other countries. There are arguments about the quality of this application, direct application of the Convention by the Constitutional Court. It's debated in legal literature right now. But at least this Constitutional Court gives a good example for lower courts. Look, we do this. You can do this as well. Don't be afraid. And quite often, district courts judges are afraid to actually look at the Convention and cite them, the Convention or the case law in their judgments, because they don't know what will happen at the appeal level. The Supreme Court, there are two observations. One is like general explanations that the Supreme Court issues by the plenum of the Supreme Court. A good example is Supreme Court says, yes, you have to apply the Convention, you have to, what is the expression, have to take it into account, plus you have to look at the case law of the European Court. This is the explanation directed to the lower courts. But when you look at the actual case-to-case practice of the Supreme Court, you don't really see direct application of the Convention. I have some recent examples where the Supreme Court said to a widow which challenged normative act by the government of the Russian Federation, which established the size of the cell, like 2 square meters. And the Supreme Court says you can't bring this case on behalf of your died husband. He has to actually bring this. It wasn't in a decision but they imply that you are not you don't have any standing because your rights were not violated, which is also questionable. District courts, there are quite a growing number of good examples, good practice of district courts implementing the Convention directly. But that's not it can't be attributed to judges' initiative. In the Constitutional Court, it's mostly, I think, this Constitutional Court judges, by their own initiative, bring the issue ahead because of the composition of this court. It's mostly professors from different law schools. But in district courts, it's mostly because of the initiative of litigators, the parties, advocates, which bring cases before the judges. And there is a strong interrelation between the initiative of the party and the direct application of the Convention by a judge. The situation is different depending on who is actually arguing the case before district courts, whether it's advocate or a member or a staff attorney of an NGO. I met and interviewed some judges, chief justices of district courts in Yekaterinburg, and also some advocates. So the picture is the following. When I spoke to judges, the judges would say, yes, we apply the convention quite often, sometimes between the lines, means we don't cite it, we don't quote it, we just take it into account. After a while, after a half an hour conversation, maybe the judge would become more, less afraid of an interview, I don't know, but finally a judge would say, of course we don't apply the convention. What are you talking about? And why should we, if none of the parties which bring cases actually raise this issue in front of us? So why should we do this? When you speak with advocates, it's almost similar picture. Initially they would say, yes, we know the convention, we apply, but then at the end of the conversation they would admit that they don't raise this issue before judges, and the explanation is that there's no, why should we spend our time in researching case law and preparing our position based on the European Convention argument when we would argue this case before the judge and judge would just ignore our arguments based on the convention. So it doesn't yield results, so we don't going to spend our time on this. So that's a sort of a vicious circle. The exception is NGO lawyers. They have, I think it's because of they have a different goal. It's not only helping a particular client, but also push boundaries of the rule of law. And the European Convention is a very good tool for this. I would give you maybe some examples. How much minutes do I have?
5 minutes.
5 minutes. Okay, one example. Recently in Yekaterinburg, there was a case of, actually 8 cases of Andrei Sychov. It's a wheelchair disabled person who actually served in the army, and there was an accident. I won't go into these details. Basically, he's in the wheelchair right now, and he's taking a lot of some cases to district courts in Yekaterinburg, and of course he has no access to courts because there are no special equipment to get to the building. It's like here, if you look at this theater, you don't see stairs. You can slide. You come on a chair, sit here, but it's very simple. But it's not happening. There are no such equipment in the courts of Yekaterinburg. So we took 8 cases to district courts, arguing that this particular person, has no access to court, physical access to court. And we argued this case based on the European Convention and some cases. And it's interesting that all of those decisions were for the applicant, of course, but the judge took these arguments based on the European Convention in order to protect his or her position before the appeal court. They knew that there is no way they can issue another decision. This person has to have an access. How to strengthen this position, the European Convention, and it helped. So what can be done about the motivation of using the convention for advocates and for judges? First of all, it should be two-way approach, coming from the top, from the Supreme Court, and from above. From the top, from the Supreme Court, right now Supreme Court distributes translation of the case law of the European Court to lower courts. But that's basically the copies. It's not an official publication. It means that it's only available for judges. If it's not published in a Supreme Court bulletin, for example, advocates, they don't have access to this translation. Or and another negative part of it is that some judges think it's not official translation. They need it to be published in the Supreme Court bulletin. there is also an issue of legal education. As it was mentioned during the first panel, the situation is like this. Under the Russian constitution, European Convention is part of the Russian legal system. It has the same force, the same power as criminal procedure law, civil procedure law. But when you look at the education, legal education, you see there are required courses which student has to take in order to graduate. On civil procedure law, criminal procedure law, and all this constitutional law, but there is no particular course on the European Convention, which, if you say it in other words, a student graduating from law school is not qualified to practice in Russian courts. That's should be remedied. Of course, it has been 13 years since ratification of the convention. There is no textbook on the European Convention, as opposed to other courses. There are hundreds of textbooks on different courses, constitutional court, law, and civil procedure law, and so on, but no textbooks on the European Convention. And I think there also should be a particular course, a master degree course on the European Convention or the international human rights protection, in order to educate potential teachers of the European Convention or international human rights law for different institutions. I think there is growing number of goszakaz. Can you help me with this? There is a development of ombudsman institution in Russia, and general ombudsman office or ombudsman of the children, and all the staff of this institution actually has to have a knowledge of international human rights protection system. Yes, I think this is the demand right now in Russia, and that's taken together. The education plus more initiative of the Supreme Court can yield the motivation for judges and advocates to actually try to use European Convention guarantees in their work litigation. Thank you.
Thanks very much, Anton. And we'll open the floor to questions in a minute or two, but at first I'm going to ask a few questions of our speakers. And the first question I have is to Alexei. When you talked about the questions about allies in the Russian government, I was curious how you would describe the Constitutional Court. Obviously, it is the institution that quotes the convention enough and has made various statements in support of Europe. At the same time, its chairman has at times been a bit negative towards the court, and the Constitutional Court has asserted that its procedures should be observed first. So when you talk about allies, how would you characterize the Constitutional Court vis-a-vis the European Court?
Well, there is very briefly, there is an institutional jealousy between these two courts, because Russian Constitutional Court has traditionally claimed that it is the most popular court, and they would cite, we had 11,000 complaints every year, 12,000, 13, 14,000, and in parallel, as Russian people learned about the Strasbourg court, they went that way too, and now we see that it's basically they are locked in. Both courts receive about 14,000 complaints every year. So there is this jealousy that who is more, well, jealousy on the part of the Russian court. I think European court would be very happy to delegate all those Russian complaints back to Russia and, breathe freely from being overloaded. But if you look at the long-term friendship between Russian Constitutional Court and Strasbourg Court, it was a friendship, and it was a real institutional friendship. The Russian Constitutional Court judges relied on the European Convention in 1996, even before Russia became a member of Council of Europe, and they had lots of trips to Strasbourg, and they say clearly that the decisions of the court, of the Strasbourg court, are the binding decisions. They apply them, they misapply them, they learn about them, so this was part. This is, I think, is at this point institutional partnership. Even though Chief Justice now speaks out sometimes, showing his critique of the court, but that's I think the issue of aging, of his age,
Mature.
rather than serious attempt to disrupt or relationship between both courts. And so I think Russian Constitutional Court is an ally of the European Court of Human Rights, and out of all Russian courts, that's the court where you would learn more about Strasbourg court than in any other Russian court.
And for Tanya, you obviously describe a very bleak situation in terms of the legal institutions in Chechnya. What Russian legal institutions are actually operating on the ground in Russia, in Chechnya?
Right, thank you for your question. Well, actually, it's fairly straightforward. In Chechnya, you've got the Investigation Committee for the Chechen Republic, which is an official body tasked with investigation into criminal cases. And you've got the Prosecutor's Office for the Chechen Republic, which in turn is tasked with supervision over investigation on the one hand, and representing state accusation in court on the other hand. So there is absolutely no difference between the way it formally looks in Chechnya or in any given Russian region. The point is, however, that investigation into the abuses perpetrated by Chechen law enforcement and security officers today just never happens. And the reason it never happens is that, first of all, the Ministry of Internal Affairs, which is also officially subjugated to the federal center, to the Ministry of Internal Affairs of the Russian Federation, but in fact is completely subservient to Mr. Kadyrov. So when there is a criminal investigation and there is a need to interrogate a particular official, a particular police officer, the police officer would never show up for the interrogation to start with, and then the investigators are just intimidated by police officials and they do not even risk sending summons, like I said in my presentation. And then the prosecutor's office, if it receives complaints about the lack of effective implementation, writes directives, writes поручения, like instructions to the investigation committee, to the specific investigators that the investigators have to abide by. So the prosecutor's office can say, for example, you have to interrogate those particular individuals, or you have to conduct those particular investigation activities. But the investigators never pay any heed to them. So neither the investigation is being done nor the supervision is being done. And like I mentioned at the event on the Hill last afternoon, in fact, the situation reached such a crisis that both the Investigation Committee for Chechnya and the Prosecutor's Office for Chechnya openly admit to being unable to do anything about those cases of abductions by law enforcement officials.
Thank you. And for Anton, I just want you to address a distinction that you made in your talk that might not be clear to everyone in the room. The distinction between advocates and NGO lawyers. Usually in the United States, we think of all lawyers as being part of the same association. But you've drawn a distinction between advocates, i.e. members of the bar, and NGO lawyers. So to what extent are they, do the membership overlap? Or to what extent do you have two separate types of legal practitioners in Russia today?
Well, this distinction is because of the possibility of practicing and litigating cases before civil courts. You can do it without being a member of the bar. If you want to practice criminal law, you have to be a member of the bar. You can be allowed to the court of law. So the distinction is quite often in NGOs there are lawyers who practice, they are not advocates, they might be advocates, but the point is that if there is a lawyer working for the NGO, it's not only about, when they bring cases before national courts, it's not only about helping a particular client, it's also working on strategic litigation. It's not only identifying the test cases and trying to make a point and to advance a particular principle of, let's say, European Convention. So quite often the goal of NGO lawyers is broader than the goal of a particular advocate. That's it's also. I can give one example of a distinction. Last year there was a case called Zakharkin versus Russia. It was about, among other things, the right of access to a client by who is in the preliminary detention center, not by an advocate, by a regular lawyer, an NGO lawyer. So under the Russian law, advocate can have an access to clients in the prison without like automatically. But if it's not an advocate, it's just an advocate and working for an NGO, you have to ask. The judge has a leverage whether to give this permission or not. So in the case of Zakharkin versus Russia, a member of an NGO which represented this client before the European Court was not granted the right to get access to the client, first at the preliminary detention center and then in the prison. So the European Court ruled that that's a violation of the right to bring a case before the European Court. An applicant has to have an access to his representative, be it advocate or a lawyer or even not a lawyer, just a regular person. But the positive thing is the facts of this case took place in 2003, 2005. But last year, during the summer, right after this decision, we had a similar case about access to a person who was in a preliminary detention center, and his representative before the European Court was not an advocate, a member of the NGO. And when we wrote an application to the judge asking for permission to meet the client, we cited this case, Zakharkin versus Russia, and some other cases against other countries, and the judge issued a permission without any problems. So that's a positive effect of the European Court.
Okay, open the floor for questions. Kathy.
Kathy Kosman. I had a question about a specific provision of the Russian extremism law and how that could, well, in fact, it already is going to come up before the European Court in the following way. Under the extremism law, any court in Russia has the right to declare literature extremist. Now there are, I believe the last count is 888 various kinds of material, mostly literature, on this list. Under theological category, the majority of the books are Muslim, including one 14-volume series by a Turkish theologian, Said Nursi, whose literature is widely available in Turkey. Now, there are several cases where the defendants have brought up this specific fact that this literature has been declared extremist as a violation of religious freedom. My question is, if the court rules in favor of the defendants, would this then call into question the fact that any court anywhere in Russia has a right to declare literature extremist, and then it's automatically banned throughout Russia?
I would say it entirely depends on the phrasing in a particular ruling, but I'd really rather leave it to the lawyers here in this room because I'm no professional lawyer. Technically speaking, yes, if the ruling is strong enough, then Russia would be compelled to change that piece of legislation, which really, really would be so welcome. But it depends on what kind of a position the court takes, right?
Anton, do you have anything?
It's always difficult to
Predict.
We have a hypothetical.
Sometimes you just have no idea how the authorities will react.
Well, let's put it this way. In some cases, when the court ruling is absolutely unambiguous, Russia definitely makes relevant policy or legislation changes. And if you are looking for recent examples, you know that gay pride has been a huge issue in the city of Moscow for like years and years. And the Moscow mayor spoke very openly about the former mayor, Mr. Lushkov, about never allowing this shameful, whatever, procession taint the streets of his city. I'm quoting pretty closely. And just a very prominent gay activist actually sent in a lodged an application with the Strasbourg court, and they won their case, which was not difficult at all, considering all those absolutely unbelievable quotes from the Moscow mayor, which were completely inflammatory. And now, for the first time in all those years, the Moscow city authorities granted permission to the gay activist to hold gay pride in central Moscow. And it's not because Moscow has a new mayor. I mean, I totally do not believe that it's an issue just of a different personality, but it's simply because they had no other way out of it after that very strong Strasbourg judgment. So if in this particular case the judgment is strong enough and unambiguous enough, then yes, some parameters in the law would have to be changed.
Do you have a follow-up on this, Laura? Yeah. Okay, we'll have a follow-up and then we'll go to China.
So, aren't there many other judgments that are unambiguous that the Russian government is ignoring? Or am I missing something? I mean, I that seems to, what you just said seems to negate some of what we've been hearing today in terms of Russia's ability to ignore clear judgments. Or is it that a lot of the cases that have been decided against Russia connote much larger systemic changes or larger investigations, so that it's not sort of, yes, you can have the parade?
Mm-hmm. But I think, and I'm speculating here, that in the case of Chechnya judgments, Russia simply ignoring them because there is no political will, and in particular there is no political will to punish high-level military officials, because we are talking about judgments where concrete generals of the Russian army or of the Russian police force are being identified by name, and Russia's just not ready to go that far. Also, if you talk about the broad variety of those cases on police torture and cruel and degrading treatment, it seems that there is no political will, but there is also no capacity B on behalf of the state to do anything. But in other areas, they actually try to cooperate. So this is a largely political issue.
I just said about whether a judgment of European court is strong enough or ambiguous. This case, the famous case Burdov versus Russia, and Burdov versus Russia #2. It was the first case against Russia in 2002, and the European Court was Streit, he said this is a violation, non-execution of national decision is a violation of Article 6. There's no ambiguity. But nothing happened afterwards. And there were many, many cases going to the European Court, 40% you mentioned. And basically European Court became a bailiff for the Russian legal system, awarding compensation. And when Burdov appealed to the European Court of Human Rights for the second time, the European Court said, okay, that's enough. We're going to issue pilot judgment where we will award not only the compensation to Burdov, because it obviously doesn't help. We would ask Russia to come up with a particular domestic remedy, which became this new law on compensation for the delay of justice, on non-execution of judgment. This is an example where the European Court decided,
Being
okay,
concrete
that's not
enough.
enough. We bring another decision. This is, in this case, it's going to be public pilot judgment.
Joanna.
Thanks. I've got a question for Tanya, but can I just follow up quickly on was
Please
it
do.
Kathy just asked? And the extremism point, I think it's a really interesting one because I think Tanya's completely right in the sense that it really depends because it's a balancing. It's one of those cases that involves balancing different rights. And if you look at Germany and some other European countries, they have anti-Holocaust denial legislations, I'm sure you know. And so in those situations, you're dealing with perhaps restrictions on freedom of expression, which you wouldn't get in this country in the same way. And that's been validated by the European Court of Human Rights. So it really depends on what basis and the claim is made and the judgment given in terms of how the domestic courts could then go forward with it. But fascinating in all respects. But Tanya, I wanted to come back to the point that you made about the climate of fear in Chechnya and the paralysis there. And we have one instance, at least one instance in the last year, of a case where action was taken by the families of two individuals who had disappeared at that stage. The case was brought to Strasbourg immediately, or brought to their attention immediately under the urgent provisions. You may know about this already. Communicated very, very quickly. And then the individuals were released.
Yeah.
But were told, they'd been ill-treated whilst detained, and were told by their captors, whoever they may be, that if they didn't drop the case as soon as they were released, then they would face consequences as their families would. I was interested to know if Human Rights Watch were aware whether there were more than one instances of that, and if there are, whether you've been able to conduct any sort of analysis or make any evidential links between how the chain of command works from communication to the higher echelons to the individuals who are releasing at the relevant stage.
Right, thank you, Joanna. Well, in the past couple of years, I've come across quite a few cases of disappearances in Chechnya where the family would initially file an official complaint. I'm not saying go as far as the European Court straight away, but file an official complaint with the investigation authorities. Then, if the individual in question was returned to them, they would immediately withdraw the complaint, and they would actually do their utmost to send the individual abroad. That's your typical concept of Chechnya justice today. But you're quite right, and actually it's something that I wanted to mention in my presentation. I felt I was running out of time. In some cases, the European Court helps much earlier than the judgment actually comes. For example, in disappearance cases, like the cases you're referring to, or there was a recent torture case where a man was actually held in the basement of the Chechen Special Task Police Force and tortured, and he was held there for 4 months, cuffed to a radiator. And what made a difference in this particular case is that indeed the family immediately approached the joint mobile groups of human rights organizations in Chechnya that has very qualified lawyers working for them from Grozny on rotation. And they immediately filed complaints on domestic level and lodged an application with the European Court. So the European Court asked urgent questions. It was not communicated, but urgent questions were asked. And as a result, there was pressure on the prosecutor generals, which turned into pressure on the prosecutor's office of Chechnya, which turned into pressure on the investigation committee, which started bothering the Ministry of Internal Affairs. And in the end, those particular people from the Special Task Police Force of Chechnya, they just felt that they would be better off by releasing the guy because there were too many questions asked and there was hard evidence that he was actually there. So yes, they released the man. And when they were releasing him, they told him specifically that he needed to go to the investigation committee and sign a document saying that he was in fact in Dagestan, you know, having a good time with married women, which is a typical story that police officers in Chechnya demand that the victims concoct. If someone disappeared, then return to the family. And he complied. But this mobile group of human rights organizations, they actually offered to evacuate him out of Chechnya together with his immediate family if he would want to continue the legal struggle. And having given that a thought, the man agreed to do that. And I have to say that this is the only case that I know out of all the contemporary cases in Chechnya where you can see at least some progress as far as the investigation is concerned. But if that case ever moves to trial, I'll be personally challenged to write a media story about it, and in particular about how much it costs a human rights organization in terms of money and human resources and time to take one single case to court, not even to win it, but just to make sure that it is moved to trial.
Right here.
I had a couple of related questions. My first question was about the, I guess, lower standard that you described for qualifying as having exhausted all domestic remedies in cases in Chechnya. Is that something that's formally recognized by either the Russian legal system or the European Court, or is it just something that the European Court kind of recognizes that they need to do? And my second question is specifically for Tanya. You said most of the cases coming out of Chechnya are against federal forces for conduct during the Second Chechen War. Are there cases coming out of neighboring republics, out of other parts of the North Caucasus, where there are similar kinds of human rights abuses, but maybe not such an extreme atmosphere of political repression?
Right, I said in particular that all these rulings that we already have on Chechen cases, they are about abuses perpetrated by federal servicemen, because those were indeed abuses of the earlier years of the Second Chechen War, when the Feds were mainly the perpetrators, with very few exceptions. Now it's all about, again, with very few exceptions, people under Kadyrov's control, and the population of Chechnya is so petrified of them that they really do not dare complain. But indeed, there are some clown cases lodged with the Strasbourg court from Ingushetia, from Dagestan, from Kabardino-Balkaria, where people are complaining about the very same abuses like abductions, disappearances, torture, extrajudicial executions. And what we are trying to argue is that if only those Chechen rulings, over 170 of those Chechen rulings, were implemented properly, the abuses would stop not only in Chechnya, but in the broader region of the Northern Caucasus, which is becoming more and more turbulent. And there is this direct connection, in fact, between the deteriorating security situation and the systemic, blatant human rights abuses that go unpunished. Because, well, it does sound trivial, but you cannot effectively fight terrorism without having the support of local communities, right? And the local communities are just losing their mind from all the abuses. So there. On the court in Chechen cases, it's not like it's formally recognized in the Russian system, but that's how those cases are essentially treated by Strasbourg, meaning that you can't submit your application right away without even trying to do anything on domestic level, and then while it's still sitting at the greffier in the registrar in Strasbourg, you have to go through the motions. You still have to show that you're doing something to find justice on domestic level. But the standard is not as high as for other regions.
Any other comments on?
Yeah, it's just on the during second Chechen war, there were no Russian courts operating in Chechnya, and Russian government admitted it. So that you could not pursue any remedies in on the territory of Chechnya, and so that's why the lawyers for the victims made the argument, and the court accepted it.
If we speak about other types of cases, for example, the European Court recognized that in cases of prison conditions, there is no domestic remedies right now existing in Russia. There is no examples where a person who was in a preliminary detention center, sitting in there in the bad conditions, was able to get a remedy, domestic remedy, in district court and then higher court. So the European Court recognized this is a structural problem and there is no domestic remedy, so we can go to the European Court of Human Rights directly without exhausting actually non-existing remedy.
Bruce.
Bruce Parrott, a fellow at the Kennan Institute. I want to thank the panelists for an extremely informative and interesting set of presentations. I have a couple of questions. One is comparative. If we look at the other signatories of the European Convention, what is their record on implementation like by comparison with Russia's? Leaving aside the case of Chechnya, which is obviously very important and separate. And then to follow up a couple of earlier observations, can you say anything in general about attitudes toward cooperation with the European Court within the Russian political elite as a whole? Are there particular groups or individuals who are identifiable either as proponents of cooperation or opponents of cooperation? For example, has anyone tried to tie this issue to the notion of modernization, Medvedev's fashionable slogan? And are there any people who favor reduced cooperation with the court, even from the current level? Thank you very much.
Why don't we start with the second question?
There are examples of cooperation of the government officials and in terms of implementation of judgments of the European Court. For example, in Sverdlovsk Oblast in Yekaterinburg, there is an ombudsman of the region, Tatiana Mirzlikova. And she's very active in terms of negotiating with the government officials about not allowing any cases going to the European Court. And the Sverdlovsk Oblast has a very low record of cases sent to the European Court. And I just recently was visiting Nizhny Novgorod and spoke with representatives of the Committee Against Torture, and they come up with an initiative for setting up a commission attached to the governor of the region, where this commission would discuss. It's not yet in working, but the idea is that this commission would discuss cases which is in communication with the government. The European Court of Human Rights cases already communicated to the government, or whether there is a possibility of settling the case with the applicant.
Yeah, who are the friends of the Strasbourg court in the old square in Moscow? So there is a part in presidential administration that cares because of the headache, because of political scandals and the international shame, and so there are some people there who work hard on this, and there is a European Union project. They spend €3 million on identifying problems and so forth. Then Dmitry Medvedev, I think, in large part, is more cooperative and friendly to the court than Vladimir Putin. And it was very visible, first of all, in the INROS report, INSOR, the Institute for Contemporary Development, that kind of think tank for Medvedev. One of the first assignments Medvedev gave to this institute was to figure out what to do with these complaints to the Strasbourg court and how we can transform judicial system of Russia in a fundamental way. And so actually, out of that, now we have in Russia the, starting January 1st, we'll have the full-blown appellate review of court decisions, of all court decisions. Prior to that, we had cassation courts, which were limited, so that hopefully will bring some respect to the Russian courts from the public. So then the presidential administration, and then it was also obvious in the scandal with appointing the latest Russia's representative at the European Court of Human Rights, who is supposed to be a lawyer representing Russia as a defendant as a defendant state. So initially the plan was to appoint a member of legislature from Petersburg who said that only public enemies and whiners, plunderers of the federal budget go to the Strasbourg court. So that guy was not appointed. Oh, I mean, he was appointed, but after one day, his name was revoked, and the other person was appointed who did not say anything bad or good prior to his nomination. So there is this internal struggles under the carpet, and but we know that there are many clans, and it depends on who we talk. Ministry of Foreign Affairs, by large, it's not a friend of European Court of Human Rights. They protect Westphalian system. They think that European Court only issues a recommendation to the Russian government that maybe Russia will follow, maybe not, but it's up to the sovereign democracy of Russia to implement them or not.
But frankly, to echo the very start of Alexei's very eloquent presentation, the best friend of the court is the public, because people are really appreciative of having that mechanism. And I remember so vividly a couple of years ago, there was a radio program, like a talk show, where one of Russian rather radical politicians was bashing the Council of Europe because of some sort of resolution by the Parliamentary Assembly, and saying that's enough shaming, we cannot put up with it anymore, we are proud people, we should slam the door on the Council of Europe. And then people started calling the studio, and it was actually pretty amazing because, well, some people said, yeah, who cares about the Council of Europe? But the absolute majority were like, but wait a second. Right, who cares about the Council of Europe? But if we slam the door in the Council of Europe, it means that we are going to lose the European Court? Absolutely no way. And it was like the absolute majority of lay people just going like, no, we need that court. So in order to have that court, we are ready to put up with the Council of Europe, whether we like it or not.
Yeah. I want to answer Bruce's first question
about
other states.
Okay.
So Soviet legacy left several big birthmarks on the Russian legal system. Mm-hmm. And so many of former Soviet republics share the same structural violations of the European Convention. So unsanitary conditions in prisons, it's across the board. Whether it's Latvia or Georgia or Russia or Ukraine, those prisons were built 100 years ago. They're still functioning and overcrowded and not good for human health. So that would be one condition. Another condition is, again, shared by many post-Soviet states, is this practice of wholesale detention prior to the trial. No matter where you look, even in Moldova, which introduced these judges, investigating judges instead of procurators, still the 9 out of 10 suspects or criminal accused get them jailed prior to the trial. And so that's, you know, the total agreement of judges with prosecution when it comes to the question of whether to detain the accused or not. That's not, I mean, you cannot simply copy paste the indictment to the judge order, you know, to detention order. So that's, this would be the structural violation. And the third violation is the same like in Russia, the non-enforcement of domestic judicial decisions. That's a big problem across the board. I mean, Kazakhstan is trying to do private bailiffs, and we'll see how, if it improves the situation, but Kazakhstan is out of the system. So.
Anton, 2 questions. First one, real easy one, I hope. Advocates, you described the difference between the lawyers working for the NGOs and the advocates. Are the advocates lawyers as well, or could they be lay persons?
Sorry, say it again, the last
Are
one?
the advocates lawyers?
Yes.
Yes,
They are.
yes.
Okay, so it's just a
I should call them members of the bar, not just advocates.
okay. They're members of the bar. Got it.
In Russian language, they're called advokati, advocates.
Got it.
So
All right.
members of the bar.
Okay. Second question, much more fundamental. You paint a optimistic picture, or at least you have a plan for better integration of the European Court's decisions into Russian law. And one is having the Supreme Court officially recognize them and publish them in the bulletin. And the second is educating the lawyers sooner all over Russia as to the fact that the judgments of the European Court are in fact law inside of Russia. The first plan seems to be relatively simple. What chance do you think there is in the near future of having the Supreme Court publish official reports of the European Court? How long do you see it might take on the other end to educate? What steps are being taken on that end? But so start with how shouldn't it happen if they're friendly courts? Was it Will or Alexei who were saying that they're friendly with each other, they respect each other?
Alexei was.
Okay.
In regard to the Supreme Court attitude, I think it's not, maybe I missed this point, it's not only about officially publishing decisions. Actually, it's not a decision of the European Court, but some extracts, the major points, or how they call it in Russia, legal positions of the European Court. They can be published. You can't publish all the body of the case law of the European Court. It's just impossible. But the important point is that the Supreme Court also have to, and high, regional courts, has to have this practice of quashing lower court judgments on the basis that the lower courts didn't take into account the European Convention. In one of the reviews of the judicial practice, the plenum of the Supreme Court actually wrote that the basis for quashing a lower court judgment should be non-taking into account the judgment of the European Court of Human Rights. It's an official explanation. But there is little examples where Supreme Court actually do this, quash lower court decisions based on non-application of international treaty. And it's not only a problem of the Supreme Court. In December last year, we had a conference in Yekaterinburg where a judge of the regional Sverdlovsk Oblast Court gave a talk, and they collected data from lower courts on the request of the Supreme Court, how the judges deal with the European Convention, the case law. And there was a very small number of cases, 226 or something like this. It's only 0.3% of all the cases where somehow judges actually refer to the convention. Well, when you look the way they refer to the convention, it's only referring to the convention. Sometimes in general, it doesn't contradict to the convention, not even an article I mentioned. there is no mentioning of the case law of the European Court. Nobody looked at the case law of the European Court. How could you make a sense of what is in the convention? So, and when during the questions we asked the judge whether there is a practice of quashing lower court decisions based on non-application of the convention, the judge says, no, we don't have it. That's the real picture. And so the education, well, that's it can take years, but we should start it right now. To
You start it right now, sooner.
it's like when in '98 we initiated this project with Interrights on teaching advocates, human rights NGO lawyers, on the European Convention, and afterwards there was a project of the Council of Europe with the Academy of Judges, educate judges. So I think if right now some private universities, let's say in Russia, in cooperation with European universities or American university, will start a program of, let's say, master degree on European Convention on Human Rights. Maybe some later, a year or two, some state university will follow. So that's.
Can I
That's it.
Yeah, I just want to add about this proposal to start from the top down to publish the decisions of European Court of Human Rights. I mean, if you look at the history, the Chief Justice, who is the same person since 1985, he's been telling Russian judges to apply European conventions, that do not approve detentions in wholesale, otherwise it will be a surge of cases, lawsuits against Russia in the Strasbourg court. The Supreme Court published this 2003, the libel, defamation, freedom of speech, freedom of the press kind of application of convention or guidelines, and other things. The problem is that at the regional level, all this speak by the Chief Justice of Supreme Court does not. I mean, it looks like they are just ignoring whatever Supreme Court says. And I think we'll have to look down at the appellate level. If you look at the Chief Justices of the appellate level courts in Russia, 8 out of 10, so 80% of them, became a judge. The initial appointment as a judge was prior to 1990. So these are all same old guard, Soviet trained judges. And another thing to remember is that Russia is a complicated country. Its bureaucracy, its judicial system is also complicated. It doesn't mean if Vladimir Putin or Dmitry Medvedev say something, it gets implemented right away. I mean, we have data on the implementation rate of presidential orders or directives. So in 2002, Vladimir Putin, 40% of his directives were implemented. In 2006, 60% of his directives were implemented. President Medvedev keeps saying that it's the same problem with him, that bureaucracy, Russian bureaucracy in the regions and federal bureaucracy do not implement whatever orders presidents issue. So there is this additional layer of problems in terms of complying. So even if we have good people on top saying clearly what to do, it doesn't mean that people on the ground will obey.
My name is Susan King. I'm with the Foundation for Russian American Economic Cooperation in Seattle. I'm curious about how the European Court manages to maintain such a high approval rating among the Russian public, among Russian citizens, when the vast majority of cases are deemed inadmissible. So most of the people who apply never even make it to the court or are reviewed by the court. And I'm wondering if that's a commentary on the Russian judicial system in general, that this is the last hope, that they have no other outlets to seek justice. So I'd be interested in your comments on that point. And also, if the panelists could say a little bit more about how the court and court decisions are portrayed in the Russian media, because that may play into this question as well. Thank you.
Can I can start.
Okay.
Very quickly. So, in the past several years, Russia loses about 200, 220 decisions a year. So it's basically one decision every day, every working day, and the media reports, wow, Strasbourg court awarded 10,000 euros or 100,000 euro or 5,000 euro to people from all over the country. You know, Chernobyl cleanup workers, some pensioners, some single mothers, victims in Chechnya. I mean, if you get this every day, if you get this on the news that here, you know, 5-digit numbers are awarded of compensation and Russian government complies, it's already in Russian. You don't need to make any PR campaign about this. It's nobody says the same good thing about Russian courts, domestic courts. Nobody says that. If somebody, wow, you know, is the icicle falls on a, you know, on a person and this person is wounded and gets a compensation from court, you know, that type of news may get into the local media and be like, but those judges were not heroes who would say, well, we award stuff, right? Because public perception is that we don't trust Russian judges. We don't want to be friends with them. But Strasbourg court is every day, and every day there are, you know, thousands and thousands of actual money being awarded. So that's why I think the popularity is there.
Well, it's also getting a kick out of seeing the state punished, because frankly, lay people in Russia, they have little trust in officials on the one hand, but they also feel generally helpless via state. They feel like they do not really influence state decisions. So this whole idea about the state being forced to pay up for its own failures is very appealing to the public.
I think there's also about procedure, how the European Court deal with cases. When you practice law in Russia and then European Court, you can see the difference, how you argue the case before the national court and how the judge receive your arguments and how these arguments are treated by the European Court is absolutely different. So доверие, more trust to the European, it's more of a trust to the European Court, although there are some disappointments with the European Court as well. About the media picture, there are maybe 4 or 5 judgments of the European Court against Russia were actually published officially in the Российская газета, and since then there was no official publication. And if the media is forced actually to speak about a particular decision, I'm mostly talking about printed and TV stations, TV channels. Sometimes they omit some facts. For example, there was a recent judgment by the court, Rantsev versus Cyprus and Russia. It was about the death of, about trafficking of a Russian girl to Cyprus and her death in Cyprus. Her father investigated the case and brought the case before the European Court, and it's a very strong case. It's very unbelievable what happened. And so it went to the media, Russian media. But when this case, her father, the applicant, appeared in the channel first, канал номер, Первый канал, the guy who was leading the program, he actually referred to the case as Rantsev against Cyprus versus Cyprus, and omitted Russia. So that's how they try to deal with them.
Well, I have one last question before we take a break, and that is, we've talked a lot about the convention and the European Court, but I'm curious, where does this leave the actual Russian Constitution? Are there specific flaws in the actual drafting of the Constitution that the European Court addresses that are not there, or certain rights that the European Court provides for that are not that are absent in the Constitution?
Really
or is the Constitution, is it simply a matter of enforcing the existing rights?
The country has a fairly decent constitution. It says it clearly in the constitution that international conventions and international obligations supersede the domestic law and become part of the domestic law. So from that viewpoint, the constitution is fully sufficient, right?
It's, yes, it's not about the differences between constitution and the convention. Actually, Constitution was drafted based on the European Convention. All the drafters had a text of the European Convention. It's about basically implementing when I was speaking to lawyers and judges about the convention, some of them would say, "Oh, we don't need. The European Convention doesn't bring anything new to the Russian legislation. We have everything we need." But these people usually don't take into account what's new the convention can bring to the enforcement application of the standards, not to the standards themselves. They don't look at the cases of the European Court when they express this point of view.
Yeah, very briefly. Article 35 of the Russian Constitution talks about compensation for public takings of property. And it says that the property has to be compensated in full. So European Convention says this for property protection, compensation for taking of property should be fair. So guess what the Russian courts use as a standard now?
Laura had one last point here, actually.
Thanks. I just wanted to return to the issue of the public's view and the media, and I know this is not a conference on the media, but I guess I'm trying to wrap my head around what you said, Tanya, about people calling in about the European Court. First of all, I can't imagine anything similar happening in this country because no one would have any idea what was going on. So I'm assuming Russia's kind of the same, so I'm sort of surprised you've said they like to see the Russian government be slammed, but I mean, this has been this issue that the human rights community has been working on, the issue of trying to increase public demand for human rights has been this very difficult issue and a real priority of the human rights community, and it sounds like you're saying that somehow the European Court has raised the profile of this important convention in the general Russian public, and also the other side of that is it sounds like the media is actually covering it, which is interesting just given what we read about the control of the media to a degree. So I'm trying to get a handle on that.
Right, well, several points then. Russia's public is generally unhappy about Russia bashing by different international organizations and politicians and foreigners in particular. But this is very different because what people find so appealing is the state being punished in favor of a specific individual, someone just like them. And people see so much injustice around them and have so little trust in state institutions that this really works. And yes, you're quite right. The European Court did a lot to raise the profile of the convention in Russia. Actually, Russians now know what exactly it is. And I would also say that it's done a lot to raise the profile of human rights work in Russia, for that matter. And the most effective mechanism of human rights protection that there exists in the country, well, in connection with the country, is the European Court. And the judgments really do get covered in the media. The problem is, however, and I'm wondering whether my colleagues would agree with me on that, is that sometimes the sensationalist aspect of particular stories would be really emphasized in media publications, or the actual compensation, but not some very important language which the court uses in the judgments, and that has to have direct impact on domestic legislation and law enforcement practices. So the journalists are more than willing to write about those victories of private individuals in the European Court, but at times they really miss the human rights point of the story.
Yeah, it depends on the journalist
Yeah,
and the newspaper. Some of them, yeah. But I wanted to add another puzzle.
One last point.
Sentence.
Last point. We're already late for our break.
Russian judges who do apply European Convention and you cite European Court of Human Rights tend to be those judges who are appointed, who have been appointed by President Putin. The person who blames court for being politicized and biased and anti-Russian.
That's an interesting conclusion.
Very good. Well, I'd like to thank our panelists for really just a very enlightening presentations and program. We're a little over time, so why don't we take about a 15-minute break, and we'll begin again around 3:35. So there's coffee outside. Thank you very much for a great panel.